Hello, this is Dr. Herskowitz, and we're going to get into the meat of the course. This video is going to be talking about Chapter 1, the legal foundations for business. Please note that you only need to read up through page 20 on this chapter. Okay, the learning objectives is to have a good understanding of how the law and regulations are fundamental to business, understand what stare decisis is, and how that is different from the common law and the civil law nation. Stare decisis is the basis that we build the law on in common law countries such as the United States and the UK. And we're also going to look to classify what legal sources lawyers turn to in answering legal questions. There's a priority of different types of sources of the law and which source is superior to other sources. Okay, the United States is a nation of law. This was stated by John Adams in the Revolutionary when the Constitution was formed. It's been the statement of legislatures, justices, and supreme justices ever since. Well, what does that mean? Well, law is the rules that are established by the state, and then they're backed up by some type of enforcement, either a financial penalty or a criminal penalty, which could be incarceration. It's formal social force, and the adequate enforcement institutions are necessary to maintain a order in society. If you have the law and no enforcement, then it's worthless. If you visited or lived in countries where that is the case, you understand what I'm saying. So it's not only a country of laws, but a country of laws that are enforced. The law is rules. They're created by the state and they are enforceable. Laws are generally and equally applicable. That means that the laws apply to all members of society, from the president down to the janitor in a local office. All of these laws are effective to these people, to citizens of the United States or to residents or to people that affect the United States. The rule of law nations adopt laws supporting the private market. Judges play a pivotal role in maintaining the rule of law. Laws are made generally and equally. That means that they are applicable to all the different groups and they are applied equally to all the different groups. Sometimes that's not the case. There are certain classes, maybe certain individuals, certain groups that appear to be above the law, but in a country with a rule of law, that is not the case. So, answer to yourself, what is the rule of law? Okay, let's take a look at how that law is applied to one primary concept that we have, and that is property or ownership. This is more than just real estate. This is dealing with the concept of property itself as it applies to people and what they own. Property is the exclusionary right that people have to use their property as they want to and to exclude others from using that property. It provides an incentive for development. Central concept in Western legal systems. Western culture has flourished because the rule of law and countries that depend on property rights being honored and protected. The Mystery of Capital by Hernando de Soto is a great little book that talks about why the West has such great wealth and the rest of the world is struggling. And that is because we have a property system that is reliable, enforceable, and that the lenders can rely on it, and that will then free up capital, free up money that is otherwise trapped in property. It's a great little book. If you get a chance to read it, please do. I use it as a key source in my international economic development class. Okay, property includes ownership of individual, constitutional, and human rights. So it's a very broad concept. We have a little chart in the book that shows the wheel of property, all the different types of property concepts that we're talking about during this course. Classification of law, you have common law and civil law. Common law is the law that comes from the United Kingdom, from England, basically the British colonies. Civil law comes from Roman times. It's also called Code Napoleon, and this is a law that does not rely on precedents. We'll be talking more about that later. You have public and private law, one dealing with the public generally and the other with private contracts and private actions. You have civil law and criminal law. Civil law is not the civil law type of law as talked about earlier. It is the law that deals with non-criminal actions. And you have criminal law where the plaintiff is the state bringing a legal action against somebody that has broken the law. Civil actions are cases of individuals against individuals. And then you have substantive law, which is the actual statement of the law itself, and procedural law, which many people think is not that important. But if the procedures are not being followed, you can lose a case or not even get it into court. So there's two aspects of the law, both substantive, the meaning of the law, letter of the law, and procedural on being able to enforce it. As I said before, there's two major legal systems. There's civil law based on a statutory codification, comes through the Roman system. Europe, South America, many parts of the East are all civil law countries. Common law is based on the written judicial decisions that establish precedents. The precedence is set from one case to the other. It is important to note that not every case sets precedents for every other case. There is a hierarchy of lower courts and higher courts. So lower courts have to follow the precedents of higher courts. Higher courts follow their own precedents, and in the United States, the highest court is the Supreme Court. Common law emphasizes the role of judges and relies on stare decisis, that the previous decisions set the standards going forward. Okay, civil law relies on legislation rather than judicial decisions. There's a couple of other types of law in the world. You have communist law, which was in the Soviet Union and its sphere of influence. And then you have Sharia law, which is a religious law of the Muslims and is the law in many countries. But we're only going to be talking about common law and civil law. Here's the countries where you see common law, and examples of countries where you will find civil law. In the United States, there is one area, Louisiana, that actually operates at the state level under civil law, and that's because it was a French colony, a French owned part of the U.S. before the Louisiana Purchase, but they kept their civil law in place. Public law includes matters involving regulation of society. Private law are the legal issues between individuals, contract, property, and tort, and that's what we're going to be talking about in this class. Civil cases, private parties are litigants. Criminal cases, the government is the plaintiff charging a crime against the defendant. Read about substantive and procedural law. Sources of law, you have the federal law, you have state law, and then you have decisions, the court decisions. Federal law, you have Constitution, which is preeminent, legislation, and then you have administrative laws and regulations, and then you have case law interpreting these laws. Federal law preempts state laws. If the federal Constitution does not state anything, does not have any rights, then everything that is not covered in the Constitution is the right of the states. But if the Constitution deals with an issue, the laws of the legislation and the Constitution preempt any state laws. When you're interpreting constitutional, legislative, and regulatory laws, judges issue opinions. These become precedents. They are cited based on the actual case itself. And stare decisis, let the decision stand. Judges are obligated to follow precedents from their court and courts superior to them. This ensures a certainty and predictability in the law so that people can plan and know what their decisions, how they would be interpreted in the legal system. In the issue of conflicting precedents, you may have one appellate court saying one thing and another appellate court saying something else. All of the district courts, all of the junior courts in that district must follow the precedent set by the appellate court. So you'll have two different strings of cases coming out. It is up to the U.S. Supreme Court to resolve those types of conflicts and come up with a decision that therefore every appellate area must follow. The hierarchy, you can see this, how the hierarchy, it means that the U.S. Constitution and amendments have precedence, and you can see all the way down. Case law is the lowest level, but it becomes very high because judges use case law to interpret the Constitution and amendments. So while case law is low, the interpretation of it often influences what that means. Legal sanctions are methods of enforcement. Courts to enforce a legal compliance with the obedience of the law. In criminal cases, the sanctions are court time or jail time. A person can be put in prison. In civil actions, it is usually financial judgments. Crime is a public wrong against society. Punishments: death, imprisonment, fine, removal, disqualification. And in breach of contract, there's failure to perform a contractual relations. There's different types of damages, and there are no punitive damages in contract law. We'll be talking more about that in the coming weeks. A tort is a civil wrong other than a breach of contract. You have intentional torts, you have negligence, and you have strict liability. We'll be covering that when we go into torts in much greater detail. The remedies are compensatory damages. A person can get compensated for the loss that they have. We'll be talking about that. And then there's punitive damages, exemplary damages in a tort case. Remember, there are no punitive damages in contract cases, but there are punitive damages in tort cases. And sometimes civil cases will span both torts and contract. For example, fraud is both a tort and also a breach of the contract. So it's important to know which type of law you're claiming if you want to have punitive damages. Okay, that's all for this video. There'll be other videos this week as well. Thank you very much.